Hi everyone, my name is Beth Brown and I am counsel in the pensions group at Mayer Brown. Welcome to this episode. In these episodes, we cover different topics each month, providing an overview of the issues faced by pension industry practitioners and offering some practical insight. Time spent listening to these episodes can count towards solicitors' continuing competence and PMI CPD requirements. All the episodes are available on our Mayer Brown YouTube channel, as well as iTunes, Google Play and Yahoo. You can also subscribe to this channel so that new episodes are shown automatically in your subscriptions feed. Hi everyone. In this episode I am going to talk about the draft regulations which the government is consulting on, which make changes to the regime for notifications that employers to defined benefit schemes need to make to the pensions regulator. You'll have noticed that there's a running theme to my podcast this year, and that theme is the Pension Scheme Act 2021. This episode is no different. You will likely recall that the Pension Scheme Act widened the notification requirements in connection with defined benefit schemes. The Act requires the appropriate person, being the employer to a scheme or any person connected or associated with the employer, to notify the pensions regulator of certain prescribed events, of any material change in or in the expected effects of that relevant event, and if the relevant event is not going to or does not take place. The notification must be accompanied by a statement setting out a range of additional information about the event. A copy of this statement must be sent to the trustees at the same time that it is given to the pensions regulator. As with other aspects of the Act, the detail, including the list of the prescribed events and the contents of the accompanying statement, was to be set out in regulations. The government has now published and is consulting on the draft Pensions Regulator Notifiable Events Amendment Regulations 2021. These regulations make changes to the list of employer notifiable events and prescribe the events affecting a defined benefit scheme employer which a notice and accompanying statement, often referred to as a declaration of intent, must be given to the pensions regulator and the scheme trustees. The government's consultation closes on the 27th of October and the regulations are intended to come into force on the 6th of April next year. I will now talk about the detail of the regulations. As we all know, the devil is in the detail. The regulations make changes to the list of employer notifiable events. Firstly, they remove wrongful trading from the list of employer notifiable events. This amendment does not intend to diminish the seriousness of wrongful trading, but rather reflect the reality that the requirement is ineffective, because a director guilty of wrongful trading is highly unlikely to admit this to the pensions regulator. And indeed, the pensions regulator has, to date, never received such a notification. Secondly, the regulations amend the existing employer change of control notifiable event. The change has been suggested to make it clear that the notification should take place when a decision in principle is made. A decision in principle is the point at which the decision to go ahead with an event is made, prior to any negotiations or agreements being entered into with another party. The reason for this change is that the pensions regulator is trying to ensure that it and the trustees of defined benefit schemes are involved much earlier in the corporate activity process. Thirdly, the regulations add two new employer notifiable events, being A decision in principle by the employer to sell a material proportion of its business or assets, and B, a decision in principle by the employer to grant or extend a security over its assets where that grant or extension would result in the secured creditor being ranked above the scheme in the order of priority for debt recovery. I will move on to the new declaration of intent requirements now. Before I do though, I just want to make the point that the notifiable events regime and the declaration of intent regime are separate. This means that a single event could give rise to obligations under both regimes. If this happens, the obligations under both regimes must be complied with, even if you think there is some overlap. Moving on to the Declaration of Intent requirements now. The regulations set out the events which will require a notice and accompanying statement to be given to the pensions regulator and the trustees of a defined benefit pension scheme. These events are 1. The intended sale by the employer of a material proportion of its business or assets, provided that main terms of the sale have been proposed. 2. The intended granting or extending of security by the employer over its assets which would result in the secured creditor being ranked above the scheme in the order of priority for debt recovery, again, provided that the main terms of the transaction have been proposed. And 3, where the employer is a company, the intended change of control of the employer, provided that the main terms of the change have been proposed, or alternatively, where a change of control occurs without a decision to do so having been taken, the actual change of control of that employer. The regulations also set out information to be included in the accompanying statement. That information is a description of the event, including, where relevant, the main terms proposed, any adverse effects of the event on the scheme, any adverse effects of the event on the employer's ability to meet its legal obligations to support the scheme, any steps taken to mitigate those adverse effects, and any communication with the trustees about the event. The intention behind these changes, as I mentioned, is to make sure that the pensions regulator and the trustees of defined benefit schemes are involved much earlier in the corporate activity process. I think the idea is to make employers give any defined benefit schemes necessary due consideration, which is obviously helpful in protecting members' benefits, but the changes are not intended to stifle corporate activity. It's a fine balancing act, and it remains to be seen how these provisions will be applied in practice and whether they go far enough or they go too far. Watch this space. Thank you for listening. This episode is an overview of the law in this area, and how the law will apply in any particular case will depend on the individual circumstances. Please therefore remember to seek legal advice on your particular circumstances.